Okay.
Ready to go?
Yeah, go ahead, Don.
This is former Congressman Don Manzullo from Illinois, now adjunct instructor at Rockford University. And today we have a very exciting guest, Jason Mazzone. He is the University of Illinois professor of constitutional law, a director of Illinois program on constitutional theory, and he's going to talk to us today about constitutional issues and crisis in foreign policy. The first of one of 937 lectures that he's going to give on this topic. And so within a brief period of time, an hour and 15 minutes, he's going to give us an overview as to what's going on, and then I'll be adding some comments involving the War Powers Act. Jason, go ahead. Or Ron, did you want to say something first?
No, we're glad to have you here, Professor.
Great. Thank you so much. You know, one of the sort of silver linings of the coronavirus pandemic is that I was able to meet Dawn and the good folks at Rockford and able to participate now in a second event that Dawn is jointly organizing. So that's been great. Thank you so much for inviting me to speak to you today. And today, at least if you're watching live, is Constitution Day. September 17th was the date in 1787 on which the delegates to Philadelphia signed the Constitution, and the convention is adjourned. That isn't the end of the process. In a sense, it's just the beginning, because then the Constitution goes to the states for ratification. Congress has designated September 17 Constitution Day. We don't get the day off. In fact, there's an obligation. Educational institutions that receive federal funding are required to hold a program observing the day. But this is a good day on which to speak about the Constitution and foreign policy or foreign affairs. And it's a good year in which to talk about these issues, because there is this is a presidential year, of course. And as I'll say more in a moment, the president, in addition to exercising lots of powers domestically, today exercises lots of power in the area of foreign affairs, more than I think that anyone on this day in 1787 would have imagined. I want to start out by talking about the Constitution and flagging some of its provisions. And doing that requires, of course, attention to some historical context. Today, the United States is extremely active on the world stage. And we have a presidential election coming up, and people around the world are paying close attention because the result will affect them as well as us. People around the world will be watching the results as they come in. You know, when was the last time Americans were glued to the television to watch election returns in a foreign country? The foreign policies of the United States matter a great deal, but it didn't start out that way. And the Constitution in 1787 or 1789 is not a blueprint for a government that is going to be actively involved in foreign affairs or a world leader. Quite the opposite. It's a constitution for a country that it's thinking of itself as modern, has political and economic and social ambitions, but remember, had just a few years previous been a remote outpost of the British Empire. The men who designed the Constitution certainly have a sense of the world, of world history, of world affairs. And yes, they view their project as one of global historical significance. After the approval of the Constitution on September 17th, I said it goes to the states, where ratification is not at all a sure thing. And when the people of New York are thinking about whether to ratify, you get these opinion pieces that appear in the newspapers under the name Publius, what we call today the Federalist Papers. In the first of those, written by Alexander Hamilton, you might have heard of him from the musical, he tells the citizens of New York this. He says, "It seems to have been reserved to the people of this country by their conduct and example to decide the important question whether societies of men are really capable or not of establishing good government from reflection and choice, or whether they are forever destined to depend for their political constitutions on accident and force." In other words, in Hamilton's view, it has come finally to us, to this country, to determine for history whether a republic can be sustained, whether people are capable of self-government. So there's certainly an eye to the place of the United States in world history. But the immediate concerns, and those that are given most attention in the Constitution, are more practical and more domestic. The real challenge at the time is figuring out how to unify the 13 former colonies, which upon independence become sovereign states. And they lose the thing they had in common, the fact that they were all British colonies. That was the thing that they shared. And the challenge is, how do you unify them after independence and keep them united going forward? The sense of difference is tremendous. In Virginia, in the 1780s, foreign means Massachusetts, right? That's foreign. And with domestic unification being the main focus, from a modern perspective, the Constitution is largely an inward-looking document. It isn't a document that is principally about a nation that will be a world leader, even if some political leaders, mentioned Hamilton at the time, thought of their individual roles in those terms. Let's then look at the preamble announcing the purposes of adopting the Constitution. It says, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare," meaning domestically, and to secure the blessings of liberty to ourselves and our posterity. It's all about us. This is not, and we'll spread our ideals throughout the world. There's none of that. That is not the purpose of the Constitution at the outset. It's a framework for a country that is largely, but not entirely, isolated. It's not a document that anticipates, say, empire building. Now, this doesn't, of course, mean that nobody imagines that there will be no interactions with other countries and their peoples, that there's no attention to foreign affairs in the Constitution. It would be wrong to conclude that. But before turning to those aspects of the Constitution, I want to emphasize again that the document is more domestic than global, more practical than ambitious. Okay, so if we step away from foreign affairs for a second, and also put to one side constitutional protections for rights, there are two big organizing themes to the Constitution. One is federalism, the division of power between the national government and the states, and the other is separation of powers, allocations of authority among the three branches of the national government. And these two themes are very much in play with respect to the provisions of the Constitution that address or anticipate foreign affairs. Those constitutional provisions, like much else in the Constitution, reflect choices about who is going to do what, but with some degree of incompleteness, because it is a constitution, not a statute, so that there are then disputes that arise over how the lines should be understood to have been drawn. And that is the question that underlies multiple issues of foreign policymaking and foreign affairs, certainly today. Where is power allocated? Who should be doing what? So let's start then with Congress. There are multiple places in the Constitution where Congress is given power. Article 1, Section 8 is one such place, and there's a list of congressional powers there. Several of those powers pertain to international activities. So just sort of going down the Article 1, Section 8 list roughly in order, one power Congress has is the power to borrow money in the name of the United States, including from foreign creditors. This isn't a new thing. The Continental Congress borrowed heavily from abroad, from France, Spain, and from the Dutch, and from others to finance the Revolutionary War. So there's already a history of engagement with international loans and banking. After Yorktown, actually, the credit rating of the country shoots up and that of England drops, and the Congress is able to get a big infusion of cash because America is now seen as a very safe investment. The power to borrow, including from abroad, is given to Congress in the Constitution. Engagement with the banking system, which is largely structured outside of the United States, is understood as essential for building a new nation. The next thing in Article 1, Section 8 is that Congress has power to regulate commerce with foreign nations as well as among the states, interstate commerce. So international trade is expected, and it's Congress, not the states, that gets to regulate it. A part of that international trade is, of course, trade in people. And the Atlantic slave trade is protected in the original Constitution. Protected from what? Protected from Congress using its power to regulate commerce with foreign nations to ban the import of slaves. Congress will be tempted to do that because the Atlantic slave trade is widely viewed as the most odious part of the institution of slavery. But the first provision of Article 1, Section 9 of the Constitution, which is a list of things that Congress specifically cannot do, says that prior to 1808, Congress cannot prohibit slave imports or tax them out of existence. Although I should say it doesn't refer to slavery specifically. There's no mention of slavery or slaves in the Constitution until the 13th Amendment. But this is what that first provision of Article 1, Section 9, referring to importation of persons means. So no congressional interference with the slave trade, even though it is a form of international commerce that Congress could otherwise regulate. And then there's more in Article 5 of the Constitution, which tells you how you can amend the Constitution. There are just two substantive limits, or two changes you cannot make. One is you cannot change representation, equal representation of the states in the Senate without their consent. The other is that prior to that same date, 1808, you cannot undo this prohibition in Article 1, Section 9 on Congress interfering with the Atlantic slave trade. So there's this double security against Congress, empowered, as I said, to regulate international commerce, shutting down slave imports. Congress also has power to establish a uniform rule of naturalization. So people are coming in, joining the political community. There's also that aspect of foreign affairs. We understand this power of naturalization today to mean that Congress gets to regulate immigration comprehensively. But the original power is much more modest. It's only with respect to naturalization procedures and requirements. The question of coming and going from abroad was left to the states, reserved powers of the states under the 10th Amendment. So that aspect of foreign affairs was originally and for a long time in the hands of state government. Comprehensive federal immigration policy is a modern development, an expansion of the understanding of the original power Congress was given in a way that shuts states out of this aspect, a quite important aspect of foreign affairs or foreign policy. Congress also has power to define and punish piracies and felonies committed on the high seas and offenses against the laws of nation. So power that extends beyond the geographical scope of the United States, and a recognition that international law, the law of nations, may also apply domestically. So we're not simply cordoned off from international law. We are, as a constitutional matter, part of the community of modern nations. So banking, commerce, immigration, adherence to international law, all features of foreign affairs that appear in the original Constitution in the list of Congress's power. Now, I'm not done with Congress because you then have a set of powers that deal with national security. There's going to be the other side of foreign affairs when, other sorts of foreign affairs efforts go south. But before I talk about that, and it's the piece of foreign affairs that gets the most attention in the Constitution, I want to skip ahead just for a second to the president. Article 2, Section 2 of the Constitution lists presidential powers. It's a much shorter list than Article 1, Section 8, the congressional power. Remember that when we get to talking about the rise of presidential authority, particularly on the issue of foreign affairs in the modern period. Well, what's on the president's list of powers related to foreign affairs in the Constitution? We have a few very specific things, but before getting to them, we have what appears first, which is that the president is vested with the executive power. And this notion of the executive power will turn out to be the basis for presidential assertions of power over certain functions, including exclusive power, including in the area of foreign affairs. Presidents take a very broad view of what this notion of the executive power means. That's getting a little ahead of the story. We'll come back to that in a moment. On the more specific presidential powers, one power of the president pertains to treaties. So diplomacy is anticipated. The president has power by and with the advice of the Senate to make treaties, which are valid if approved by 2/3, a supermajority of the senators. Now, treaty making is also nothing new. The Revolutionary War, of course, ends with the signing of the Treaty of Paris on September 3rd, 1783, for example. But note here that power is divided between the executive and one chamber of the legislature, the Senate. And we'll come back to treaties later on. Also on the diplomacy front, the president has the power to nominate ambassadors subject to Senate confirmation. Again, power shared, that's Article 2, Section 2. And in Article 2, Section 3, the president has power to, indeed is required, it's an obligation to receive ambassadors from abroad. This doesn't sound like much, but it too will turn out to be a significant source of presidential authority. And then that leads us to the federal courts in Article 3. What do they have to do with foreign affairs? I already mentioned the law of nations, so perhaps some role there. But ambassadors reappear in the list of federal judicial powers in Article 3, Section 2. It sets out the kinds of cases the federal courts can hear, with everything else left to the state courts. And on that list, the federal courts may hear, they're empowered as a constitutional matter to hear, cases affecting ambassadors. So ambassadors are not stuck in state court where they might not get a very favorable reception, but can proceed in federal court. And there's more cases involving ambassadors are also included in the very short list of cases that the US Supreme Court may hear pursuant to what we call its original jurisdiction. That is to say, in the first instance. In other words, ambassadors can start at the very top at the US Supreme Court. They don't have to work their way through the lower court system in the way that ordinary litigants do. They get special treatment, doubly so in the federal judicial branch. And then one other bit of foreign affairs in Article 3 is what is found in Article 3, Section 3 of the Constitution, which deals with treason. It's the one place in the Constitution where there's a definition of a criminal offense. It tells you what treason is, along with the requirements of proof and specification of punishment. Treason is a foreign affair that is a betrayal of your country, and there it is in Article 3. Well, that brings me then to the issue of national security more generally, which, as I said, is the aspect of foreign affairs that gets the most attention, at least measured by word count, in the Constitution. And here we see quite vividly these two themes that I mentioned, federalism and separation of powers, in play. And we also see the quite inward-looking nature of the original Constitution. The national security element, which is a big piece of the original Constitution, is not about invading other countries, fighting wars in foreign lands, capturing territories, dismantling governments in distant lands, and so on. It's about securing the nation from threats, ensuring the means to respond to hostilities, to threats that are brought to us. With more than 2 centuries of national government behind us, it's easy to forget that in the early years following the Revolutionary War, it was far from certain that the American experiment in independence would succeed. 18th century America was a precarious setting. Although they defeated the British, Americans remained preoccupied with the notion that there were forces conspiring against their freedom. One threat was foreign invasion. This category at the time included attacks from Indians. The proximity of British and Spanish settlements was a constant source of unease. Wars in other parts of the world, particularly Europe, might spill over into the American continent. And in addition to external attacks, violence might erupt from within. Sleeper cells might seem like a new evil, but 18th century Americans took for granted that foreign sympathizers were living among them, biding their time for the right moment to strike or to stir up trouble. And if you read the original Constitution from beginning to end, which I encourage, not least of all on September 17th, you see that national security, being able to respond to these sorts of threats, gets a lot of attention and planning. So remember the preamble. The goals of we the people in establishing this Constitution are to ensure domestic tranquility and provide for the common defense. Right? Only then can we seek the general welfare and secure the blessings of liberty and so on. Security also appears repeatedly in the organization of and powers of the three branches of the national government under Articles 1, 2, and 3 of the Constitution. If you go back to Congress's powers in Article 1, Section 8, the first power Congress has is the power to lay and collect taxes to do what? To pay the debts and provide for the common defense of the United States. And if you go down the list of congressional powers in Article 1, Section 8, you find a whole series concerning national security, one after the other. Congressional powers to declare war, to grant letters of marque and reprisal. That, by the way, that's permission given to private actors to capture foreign ships. Congress, doesn't issue these today. I don't think it's issued them since about 1812. Power to make rules concerning captures on land and water. Power to raise and support armies, to provide and maintain a navy, to make rules for the government and regulation of the land and naval forces, to exercise authority over all places purchased for the erection of forts, magazines, and arsenal, to provide for calling forth the militia, to provide for organizing, arming, and disciplining the militia. And Congress also has powers, this is in Article 1, Section 9, to suspend habeas corpus, meaning access to the courts to challenge your confinement in times of insecurity. So security, 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 right? This is the big theme of the original Constitution. The first of the president's Article 2 powers is also for security. The president is commander-in-chief of the Army and Navy of the United States, right, and of the militia of the several states when called into the actual service of the United States, right? That's the first thing, right? The first role of the president is as commander-in-chief. And while courts are not often thought of as military actors, the security theme of the Constitution continues, at least in that one section of Article 3 that I mentioned, Section 3, involving treason. And this is a provision of the Constitution that, that many people don't know about, but that is actually quite important. We're sort of thinking about the national security component of foreign affairs. And it's a federalism-related provision. Article 4 of the Constitution imposes an obligation upon the national government to protect the states from foreign invasions and domestic insurrections. So there's two types of threats that I refer to. The national government must come to the aid of the states. That obligation is there because the Constitution also takes away powers from the states to defend themselves. Under Article 1, Section 10, states cannot, without Congress's permission, keep active troops or ships of war. They cannot engage in warfare unless invaded or an immediate response is otherwise needed. It's the national government that is supposed to be the key player on the security front. And states are also disabled from other aspects of foreign affairs, including aspects that may bear on conflict or on resolving it. States may not enter into treaties, and states cannot tax imports. Illinois cannot have its own trade policy for, say, Chinese goods. Can't engage in trade wars with China. This might all seem obvious today, that the national government provides security and runs other aspects of foreign affairs. But at the time the Constitution is being drafted, the states view themselves as sovereigns, and they're giving up powers that sovereign states would otherwise enjoy. And on the security piece, they understand that it's essential to make sure that the national government has both the means and the obligation to defend the states and to defend each of them. It's a power in the national government and an obligation of protection. Now, having said that, and this is, I guess, kind of a sort of a footnote, on this big issue of national security, under the original Constitution, the states did actually retain a role. It quickly turned out not to be very significant, but at the time that it's put there, it generates a lot of debate and is quite important. And it's something that we wouldn't really think about today. And it's that the states exercise significant powers over the state militia units. So the Constitution made militia units available for the federal government to use in providing security. And there was, and this was because if you did that, then the federal government wouldn't need to raise large armies. It could call forth a state militia for defensive and maybe offensive, although there were questions about that purposes. But Article 1, Section 8 says that even though that's true, the states retain authority to appoint officers of the militia and to train them. So there's Congress that can enact the laws calling forth the militia to federal service. The president then gets to command those units, separation of powers. But states are involved in training and disciplining and appointing militia officers. Federalism. Not surprisingly, this was kind of a mess because with power of the militia divided up in this way, there were lots of disputes. We don't think too much about the militia specifically these days, but this basic question of where power is lodged on national security and in other areas of foreign affairs continues on in lots of other contexts. And in particular, the questions principally involve the role of Congress versus the president. There's been, a good amount of cooperation between the executive branch and the legislative branch on issues of foreign policy and foreign affairs more generally, but there's also a long history of disputes over the allocation of power in specific instances against the backdrop of these constitutional provisions that I ran through. Now, these kinds of disputes, this isn't necessarily a shortcoming. The fact that an issue arises and you have competing claims to power isn't necessarily a defect of the Constitution. You might say it's a virtue, that there is value in one branch stepping up and saying that another branch is exceeding its constitutional authority, that the Constitution gives me power, us power in this area. Right? That can be the thing that brings attention to what government is doing or proposing to do. There's separation of powers. It doesn't work if nobody is monitoring, and the best monitors are often other power holders whose interests seem to be implicated. The constitutional issues that arise then in the area of foreign affairs are mostly issues involving which branch of the federal government gets to act. What is in the domain of Congress? What can the president do? And let's not forget about the third branch, and also to some extent, what role might there be for the court? These disputes arise because, as I said, the Constitution gives some powers relevant to foreign affairs to the Congress, some powers to the president. These powers are described quite generally, so there's a fair amount of room for each branch to assert that it has authority on a particular issue to push the power that the Constitution assigns it to its limits. And both Congress and the president may have relevant powers. Right? Remember, Congress gets to declare war, for example, and to raise and fund military forces. But the president is designated commander-in-chief. When then do questions of military activity fall within the military powers of Congress rather than the military powers of the president? We'll come back to this in just a moment. Again, often, of course, Congress and the president are on the same page, but not always. And there have been multiple occasions in which the two branches have had different views on issues of foreign policy or affairs and sought to advance their own preferences. Issues of presidential versus legislative power in foreign affairs have been around since the earliest days of the Republic. When President Washington, and I know we asked you to take a look at this, in 1793, issues this neutrality proclamation saying that the US is neutral in the war between France and England. There's this debate over whether the president can do that, with critics, including James Madison, he's writing under the pseudonym Helvidius, saying that this is lawmaking. Congress is the one that is able to do that. But Alexander Hamilton, writing as Pacific, is arguing that no, foreign affairs falls within the scope of the executive power, limited only by specific carve-outs, prohibitions in the Constitution. There's none here, and so the president gets to act unilaterally. We're still largely debating these sorts of things today in a variety of contexts, but I think also more often and with some larger implications. Okay, so when issues of constitutional interpretation arise, including questions of where power is assigned, we're accustomed today to having courts resolve the issue, and courts do this regularly when there are disputes over the exercise of power domestically or on issues of constitutional rights. And every term of the Supreme Court, there are cases in which the court decides which governmental entity has constitutional power. On foreign affairs, though, courts tend to be more cautious about getting involved. It's not that they don't ever decide issues, but they recognize the special considerations involved in weighing in on governmental actors in the foreign arena. And this is particularly true with respect to questions of national security and military activities. Courts tend to want the political process to sort out disputes rather than have things resolved by the judicial branch, especially during in the heat of the moment, when your ruling might have dramatic implications. You know, it's one thing for a court to rule, for example, that the criminal defendant didn't get a fair trial and must be released from prison. It's quite another to say the war is illegal and the troops must immediately be brought home. So we shouldn't then assume that courts are necessarily going to resolve questions or are going to resolve them in broad ways that will head off future disputes that will put to rest any future questions. The political process is more likely than the judicial to determine outcomes in individual instances and also to structure more general norms and practices. And this matters a great deal. On the political front, when it comes to foreign affairs, the president has some built-in advantages. Is in a good position to get his way, to increase his power. Indeed, many observers think that that presidents have been able to accumulate too much authority on issues of foreign affairs. So why does the president have these sorts of advantages? Well, one advantage is the president can act immediately. Congress is necessarily slower. The founding generation thought this was a virtue of the presidency. So Alexander Hamilton, right, again, remember the musical, in Federal 70, he says that the energy in the executive is a leading character in the definition of good government. It's why there's one president in the Constitution, not some kind of executive council that makes a collective decision. And the first words of Article 2 are the executive power shall be vested in a president of the United States, right? A president. Nimbleness on the part of the executive branch turns out to be a source of significant practical authority. And you can think of lots of examples. I mean, for example, if the president deploys troops, it's very hard for Congress to say, well, we haven't declared war, or to try to pull the plug on a military operation underway. If the president announces, I've reached a peace treaty with North Korea, we're all happy, it's hard for the Senate to say, we haven't been consulted, so don't get ahead of things. If the president says he is imposing sanctions on Pakistan because it's a poor record on human rights, it's hard for Congress to override that decision. The president also has information advantages. The president oversees the CIA and intelligence gathering agents, other intelligence gathering agencies with massive resources and massive capabilities. Within the executive branch, there is much more knowledge and much more knowledge gathering capacity than there is in Congress. Congress can certainly run its own investigations, but it depends heavily on information gathered within the executive, and all presidents make decisions about what to share. The president also benefits from secrecy, right, including recognition by courts of some degree of executive privilege. It's hard for Congress to squeeze information out of an uncooperative president, especially when, as is often the case, Congress may not even know what information to ask for. And information matters for public support. If you can tell your story first, you are at an advantage. And if you know more, you are also at an advantage. The president is very well positioned to say a step or 3 or 5 ahead of the Congress in informing the public and justifying presidential actions. That too is a big source of power. I mentioned that the Constitution gives the president the power to appoint and receive ambassadors. And I said, that doesn't sound like much, receive, a person comes over, you have coffee and so on. But it turns out to be a significant source of authority in the area of foreign affairs. It has come to be understood, and courts understand it this way, to mean that the president, through this reception idea, gets to decide exclusively which foreign governments to recognize and which forms of diplomacy to undertake. And that's a significant power when there are competing claims on the international stage. But the president also has a lot of information, a lot of authority, because Congress has given the president power. This is true domestically, but it's really true on issues of foreign affairs. Much of what the president does in this area is to execute laws that Congress has enacted. And Congress in those laws has given the president big grants of discretion to decide when and how those laws will be carried out. A few examples: Congress has power, as I said, under the Constitution to regulate international commerce. But most of the regulations you get come out of the executive branch pursuant to a statutory grant. And so, for example, Congress has enacted, it did so in 1977, a statute called the International Emergency Economic Powers Act. authorizes the president to impose economic sanctions on foreign countries and seize assets. And it gives the president the power to decide when an external threat exists so that these sorts of sanctions are appropriate. The president doesn't have to go back to Congress for more specific permission with respect to trade policy and sanctions for particular countries. And so, for instance, recently, President Trump, last year, I think, announced that he would use his delegated power under this statute to impose sanctions on Mexico. If it didn't control the southern border, no need to ask Congress first. This is executive policy making authorized by Congress and potentially with lots of big effects. On immigration, Congress has given the president very broad powers. One is the power simply to suspend the entry of non-citizens or groups of non-citizens into the United States, again, without having to go to Congress for more specific permission. So remember President Trump's series of executive orders invoking this power beginning in, I think it was January of 2017, wholesale bans on entry from certain countries. Lots of people complained about this, litigated against it, claimed it was illegal. But the Supreme Court, in a case called Trump versus Hawaii in 2018, upheld the reworked version, it went through a few iterations, of the executive order as a proper exercise of presidential power under the immigration law. Congress said the president could do it. Same thing with respect to entry of refugees. The president has broad statutory discretion to determine entry numbers and who and how and so on. And President Trump has used that power to sharply limit the number and the conditions under which refugees can enter the country. This is pursuant to statutory authority. Now, I don't want to give a misimpression. It's not just all about President Trump. All presidents derive power from statutes, right? And if there's a President Biden, you can be sure, right, he will be doing his thing, right, under statutory grants as well. And then keep in mind that Congress is also dependent upon the president to enforce laws it enacts. It's the president who, under the Constitution, must take care that the laws, including statutes, be faithfully executed. The power of enforcement is a big deal because you can drag your feet or maybe do nothing. There are lots of laws that presidents decide to under-enforce or not to enforce, or to enforce in any particular ways, and it's hard for Congress to do anything about that. On immigration, the DACA program that President Obama implemented is just an executive policy of not exercising power that Congress has given the executive to remove individuals unlawfully present in the country, to not execute those laws with respect to childhood arrivals. And Congress, if you've been watching this, hasn't been able either to end DACA or to make it permanent. And so long as that is true, that the president controls. Lots of other things. Congress has often given the president significant discretion on allocations of foreign aid and military assistance, and that allows the president to pursue objectives there. And I've mentioned treaties, and this one's a really striking one. Remember, under the Constitution, treaties require the president plus 2/3 of the Senate. That's a high bar. But the president regularly circumvents it, often with the cooperation of Congress. Most international agreements that the United States enters into are not styled as treaties, although that is what they are, but as binding executive agreements. And these can be either executive agreements achieved alone by the president, or congressional executive agreements where the president has either some pre-existing statutory authority or Congress subsequently approves the arrangement. So these are binding in the same way that treaties are, but they bypass the 2/3 requirement of the Senate. So if you can't count on getting the Senate 2/3, you run it as a congressional executive agreement just with majority congressional support. And notice the House is excluded from the treaty-making process under the Constitution, but is brought in through this mechanism. If you can't get it through Congress, well, then just issue an executive agreement alone. The president also enters into political agreements. They're not binding, but they have some political force, and these are never run through Congress. So remember the Iran deal that Obama entered us into, Iran shutting down aspects of its nuclear program and exchange, release of foreign assets and lifting of restrictions on doing business with Iran and some other economic incentives. This is styled as a political commitment. It's not binding in the legal sense, and so Obama doesn't run it through Congress. Congress later tries to dismantle it unsuccessfully, and then Trump, as you may know, later just ends the whole thing. All of these kinds of things, and they all enhance executive power, are simply not contemplated in the original Constitution, and I think are inconsistent with the treaty mechanism that is there. Also on treaties, the Constitution, because this has been in the news as well, the Constitution tells you how you get treaties, but it doesn't say how you withdraw from them. And presidents have on occasion said, we're out, that's it. And this too has raised disputes with Congress, again, largely because it isn't clear where power lies. Do you need the president plus the Senate to adopt a treaty? Do you need the same procedure to withdraw, or is the action of the president enough? Or does Congress have to enact a statute? We don't know. Withdrawing from a treaty is a big deal. It can be as big a deal as entering it in the first place. And unilateral executive withdrawal, that's a big executive power. And who really is in a position to check that? President Trump has withdrawn us from several treaties, including the intermediate, it's called the Intermediate Range Nuclear Forces Treaty, which grew out of Reagan's meeting with Gorbachev in 1986. Trump says, no, Russia isn't abiding by it, so we are out, it's finished. Other things too, the Paris Climate Agreement, Obama entered this alone, signing an executive order, it never went through Congress. Trump simply canceled it via his own executive order. This is an important implication of these types of agreements that involve the executive going it alone. Treaties work when they endure, right? When your partners can count upon them in the long term. But it's all just the president because that's where power now lies. Then the expiration date can become just inauguration day. I think that has profound implications for treaty making. Okay, some observers complain that Congress has abdicated the role it is supposed to play in the area of foreign affairs. This criticism arises especially on military issues. So remember, Congress has the power to declare war. Assigning this power to Congress was designed to ensure that the nation would not go to war without debate and decision by the representatives of the people. You didn't want to replicate the age-old problem of kings waging costly and maybe foolish wars, maybe for personal purposes in foreign lands on their own say-so. As you probably know, Congress has not declared war, at least not using those words, since 1942. And it's not because since that time we've been a peaceful nation. Presidents have regularly engaged in military action without a formal declaration of war by the Congress. And presidents routinely assert they can do this because of their status as commander-in-chief. They understand that term very broadly. In a way, I think that would shock the people who wrote and ratified the Constitution. The original idea of commander-in-chief is exactly what it sounds like. It's the officer who commands a military unit. Article 2 of the Constitution says, this is the president, so that means that Congress cannot put somebody else in that position. It never meant a power of the president to initiate military action, whether in an offensive or defensive posture. That decision was for Congress. Congress was given power to decide when to engage in warfare, when to end it, and how warfare would be conducted. And for a long time, if you look at these sort of early statutes, Congress would enact specific statutes saying how many troops will be deployed, for how long, what they could attack, what they couldn't attack, and so on. These things were not up to the president, who was the commander-in-chief, but merely the commander-in-chief. A couple of other things. I guess on that point, presidents have been very bold and creative, as I suggested, in thinking about their status as commander-in-chief. In the summer of 1950, for example, when President Truman authorizes the bombing of North Korea in response to its invasion of the South, he says, no need to go to Congress because, he said, quote, we are not at war. That seems strange given the circumstances, but his account was, this is a kind of policing of the Korean Peninsula, not war, so no need to worry about Congress. Congress, eventually gets concerned about this and enacts over a veto by President Nixon, the 1973 War Powers Resolution. And after I finish my comments, we'll bring in Dawn to say a bit more about this. But it purports to set some limits. Requires President to notify Congress within 48 hours of deploying troops, limits troop deployment to 60 days unless Congress grants additional authorization. And even before that 60-day period, Congress can vote to end the use of troops. So this is designed, there are more aspects of that which we can get to later. This is designed to bring Congress back in, even if it isn't declaring war before troops are actually deployed, or what is essentially war is being undertaken. But even so, presidents don't even comply always with this resolution. President Obama conducts the strikes against Libya beyond the 60-day period without congressional approval, saying, it's a bit like Truman, that the strikes are limited and they're done pursuant to NATO command. And so Congress's permission wasn't needed within the scope of the resolution. And even if Congress wants to gear up, right, the 1973 law, it might not succeed. So Congress tried to shut down President Trump's operations with respect to Iran following the drone strike he authorized on the military general. But so Trump simply vetoed the resolution. Members of Congress often complain about presidents undertaking military action unilaterally, but it isn't hard, perhaps, to see why Congress doesn't act in a more muscular way. And I'll be interested to hear sort of Dawn's thoughts about this as well, to end the practice. But as I see things, if things go badly, Congress can blame the president. And it's politically very difficult to curtail military action once it begins and troops are in harm's way. So Congress might not want to exercise its full powers on military activity, might want to prefer the president to play a larger role. And how do you force Congress to step up if it's reluctant to do so? It's far from clear. The Constitution might have been written differently, but if you'd anticipated this dynamic, you might have said, and the president may never use force except pursuant to law, meaning Congress has to say so, but the Constitution doesn't have that additional restrictive language that would have limited presidential action. Divisions in Congress also enhance executive power. For Congress to act, you need both the Senate and the House. So if they're in the hands of different parties, getting a bipartisan restriction on presidential action is a challenge. And the president can also veto, as with Trump on Iran. So you might not just need bipartisanship, but supermajority congressional support. And even if you can eventually get to that, it probably takes time. And during that period, the president can continue to act. A failure to impose a check tends to enhance executive power, I think, in the long run. Once one president has done something, it's easier for the next to do it. And pretty soon you have claims of power based less on constitutional text and more on historical practice. Executive authority tends to grow and has tended to grow in this area through practice. Justice Frankfurter said this. He said, a systematic, unbroken executive practice long pursued to the knowledge of Congress and never before questioned, engaged in by presidents who have also sworn to uphold the Constitution, may be treated as a gloss on executive power vested in the president. In other words, practice informs our understanding of the scope of executive power under the Constitution, a concept that you might find especially problematic if you recognize that it can be hard for Congress to actually limit what the president does. Now, Congress does have some potential sources of power to limit presidential action in all areas of foreign affairs, and these might be deployed robustly if Congress was so inclined. Congress can limit statutory authority in immigration or other areas. It can shut down presidential activity by cutting funding or imposing tighter restrictions on the use of funds, though that gets difficult because the president has the benefit of lots of appropriations measures, and he can start moving things around, as Trump has done, for example, in building the wall. Congress might get rid of federal agencies or restructure them or defund them. It might conduct more rigorous oversight hearings and other forms of monitoring. If it wanted, it could vastly expand the roster of its own investigators and staffers. The Senate could jam up the executive by refusing to confirm nominees to key positions. And there is also, the possibility of impeachment of the president and, if convicted, removed from office. But as we saw, earlier this year, that's a very hard thing to do. And the president, even if you deploy some of these mechanisms, has lots of ways to fight back. One is just refusing to follow what Congress has required on the ground that, in the president's view, Congress has overstepped its authority. When Congress enacted the Detainee Treatment Act of 2005 in response to concerns about how suspected terrorists were being treated, the act prohibited subjecting detainees to cruel, inhuman or degrading treatment or punishment, essentially torture. President Bush signed it into law, but issued a signing statement that read, "The executive branch shall construe this related to detainees in a manner consistent with the constitutional authority of the president to supervise the unitary executive branch and as commander-in-chief, and consistent with the constitutional limits on the judicial power," and so on. In other words, if I think that what you, Congress, has done is interfering with my role in supervising the members of the executive branch who operate under me and interfering with my powers as commander-in-chief, then I'm not going to necessarily apply this restriction that you have, Congress, imposed. I've talked a lot about Congress and the president, and in the last couple of minutes, I want to return to courts. I said that courts have courts had to tread very carefully in areas of foreign affairs, but I don't want to leave the impression that they have no involvement. And so let me flag 3 cases that I think are quite interesting for illustrating the issues in this area and the role that courts have played or might play in the future. So one is a case, they're from different periods. One is a case called US versus Curtiss-Wright Export Corporation. It's a Supreme Court case from 1936. It involves the war between Paraguay and Bolivia in 1932. And you had arms exporters, always looking to make a profit, that saw opportunities to sell their products. Congress approved a joint resolution that said, if the president determines that prohibiting the sale of weapons would contribute to peace, then he's authorized to issue an embargo on weapon sales and to prosecute anybody who violates the embargo. FDR signs this into law, and then he issues an embargo on arms sales, pursuant to what Congress said he may do. And the Curtiss-Wright Export Corporation, an arms dealer, violates the embargo at selling machine guns to Bolivia, and it's indicted. It says that Congress has unconstitutionally delegated power to the president, that only Congress itself can decide on and issue an embargo, has to be a legislative decision. The Supreme Court rejects the argument, and the decision from the Supreme Court includes very broad language about the primary role of the president in issues of foreign affairs, quite apart from the delegation of statutory authority by Congress. So the court says this, it says, the president is the sole organ of the nation in its external relations and its sole representative with foreign nations. In other words, the president alone has very broad powers in the field of foreign affairs, beyond even specific grants of power, in part because of a notion that foreign affairs is just what executives do, and the executive power under the Constitution is vested in who? In a president. Ever since, presidents have really run with this language, trotting out the case whenever they want to defend their broad claims to foreign affairs powers and minimize those of Congress or others. Second case is a case called Youngstown Sheet 2 versus Sawyer. It's from 1952. This involves President Truman. I've already mentioned him. Remember, we are not at war. This case involves something else Truman is doing. He's seizing domestic steel mills during the Korean War to head off labor strikes. That would have interrupted the supply of steel and equipment to the troops. Congress hasn't given the president the authority to seize the mills, but the president says, I'm doing this, I have power to do it. Where's that power? I am commander-in-chief. Right? We have troops engaged and we need the steel. This is a proper exercise of my power as commander-in-chief. The court rejects Truman's position, concludes that seizure of domestic factories, even if needed for a war effort in another part of the world, is not part of the president's power as commander-in-chief, and you need congressional authority in order for the president to do this. The case remains extremely influential, not so much for that particular holding, but for concurring opinion by Justice Jackson, in which he sets out a framework for assessing the constitutionality of basically everything we've been talking about, of the scope of presidential action in light of the role of Congress. It's a framework that courts use in lots of other cases, not just in the area of foreign affairs, and that presidents also rely upon in explaining exercises of their power. And the third and last case I want to mention is more recent. It's called Zivotofsky versus Kerry. The State Department, which issues passports, it's from 2015 out of the Supreme Court. The State Department, which issues passports, had a policy that if you were a US citizen born in Jerusalem, your passport said only that Jerusalem was your place of birth. And the State Department refused to provide a passport saying Jerusalem, Israel, even though the country of birth is normally listed as well, or on other passports wherever else you were born as a US citizen in other parts of the world. Why this exception? Well, not surprisingly, because of some obvious sensitivities in the region. Congress gets involved in this and enacts a statute directing the State Department to say Jerusalem, Israel, if the passport applicant wants that. The State Department refuses to follow the law, says this is an area of foreign affairs, foreign policies that we control. And the Supreme Court agrees with the State Department, it is the executive branch, that the statute is unconstitutional, that the executive branch has sole authority to recognize foreign states. That power, the court says, derives from the president's constitutional authority to receive ambassadors. Remember, I mentioned that before, right? And it says it broadens out to a kind of quite broad scope of presidential power, and Congress cannot interfere with the executive's policy. This case went to the Supreme Court twice, actually, the first time around on whether courts should even get involved in the dispute or just leave it to Congress and the president to figure out. The court decided judicial resolution was appropriate here, and the president wins. Justice Kennedy, who's since retired, wrote the majority opinion for the court. He invokes that Youngstown framework that I just mentioned. He also invokes, everything ultimately ties together, the Pacificus Helvidius debate. As I said, we're still talking about the issues raised there. And Kennedy concludes that the president's power to choose and also receive ambassadors, along with some other aspects of executive authority, means that the president has a sole power of what he calls recognition. That is to say, to recognize foreign states, foreign governments, and Congress cannot interfere with that by imposing the passport requirement. So it sounds a bit like this US versus Curtis Wright case, but Kennedy goes on to reject some of the broadest implications of that earlier decision. He says on the specific issue of recognizing a foreign state, the president has power, but many of the attendant implications would require lawmaking by Congress. And Kennedy flat out rejects any reading of Curtis Wright that on foreign affairs, generally, the president is the sole actor. He says, in a world that is ever more compressed and independent, it is essential that the congressional role in foreign affairs be understood and respected. For it is Congress that makes laws, and in countless ways, its laws will and should shape the nation's course. The executive is not free from the ordinary controls and checks of Congress merely because foreign affairs are at issue. It is not for the president alone to determine the whole content of the nation's foreign policy. There's a real pushback on the relative rise of the presidency that we've seen. Roberts, Alito, and Scalia all dissent in the case. They think the president should lose even on the passport issue. Roberts, the Chief Justice, starts out his opinion saying, never before has this court accepted a president's direct defiance of an act of Congress in the field of foreign affairs. Roberts and his colleagues think the president simply doesn't have the sort of wide-ranging foreign affairs powers to ignore the statute. And I think, this is what we should watch going forward. Across the political spectrum, there's increasing scrutiny of executive power in many forms. And when you combine that with new attention from Chief Justice and other conservative members of the Supreme Court to originalist grounded constraints on executive activity in foreign affairs, we might see some new curtailments of presidential power. The pendulum may swing back somewhat. We might get more balance, but it isn't easy. Right? For the reasons I have explained, it's very difficult to head off or respond to presidential action on foreign policy or in foreign affairs. And even after Zivotofsky, don't count on the courts. And don't even count on the election that is coming up in November. All presidents seem to like more power once they take office. So I'll end there, and certainly happy to hear from Don and others.
Well, Jason, thank you for covering hundreds of years of American constitutional history in about an hour. That was a remarkable lecture, and we're just thrilled that you could give that type of information to our students. I've got some comments I want to make, but Ron, first I want to see if the students have any questions.
Actually, I do have a question from a student.
Yeah, let's do that first.
Yeah, let me read it. You've mentioned that in Article 1, the framers gave Congress the power to punish offenses on the high seas, thus indicating some adherence to the laws of the nations. During the 20th century, the international community significantly developed international law, even establishing the International Criminal Court in The Hague. Nevertheless, the U.S. currently does not recognize its jurisdiction despite participating in the first similar tribunals after the Second World War. From a constitutional perspective, are there any rationales against the U.S. participation in the international judicial system? If not, could we expect the U.S. to ratify the statute in the future?
So maybe a couple of things there. Let me give you the exact constitutional language, because this will answer part of the question. So Congress's power to define and punish piracies and felonies committed on the high seas and offenses against the law of nations. So Congress's power to define and punish offenses against the law of nations. It's not an obligation on the part of Congress or of the U.S. in general to actually do that. A power, right, is a grant of authority if you want to use it. So it would be a mistake to say that that therefore you must adhere to international law. It's setting up the opportunity if Congress wants to do that. So that's sort of one piece of the answer. On things like on the international courts, there's a lot of really interesting stuff in this area. One of the concerns, apart from political concerns, that gets raised with respect to various kinds of international tribunals, is the concern that some of the procedures of those tribunals would not be consistent with other aspects of U.S. law, including U.S. constitutional law. And there have been actually a set of cases that have gone through the Supreme Court where there have been efforts to invoke requirements of international law to subject the U.S., for example, to proceedings before international tribunals in ways that would give individuals rights against the United States or against states. A lot of these cases involve, for example, death penalty cases out of Texas and additional protections at the international level there. The U.S. Supreme Court has taken the view that these things cannot be forced onto unwilling states or an unwilling nation because the court takes the view that this would be to supplant constitutional requirements. So whatever kind of a treaty or obligation you enter into, including with respect to adherence to international law or acquiescence to proceedings before an international court, at the end of the day, all of that must be subordinate to the U.S. Constitution. And so that, besides sort of lots of political reasons for for sort of skepticism towards some of these entities. That is a piece of it that has a constitutional dimension.
Well,
Go ahead, Don.
there has long been a strain between Congress and the White House with regard to the functioning of world affairs. One of the problems has to do with the fact that members of the House are elected every 2 years. The average stint in Congress, I think now is somewhere around 8 years, maybe 4 terms. So you don't have a lot of sustainability in the House in terms of resident experts on particular fields. And that finds its way deeply into the corridors of management in terms of foreign affairs. You have to have that real long-range perspective, and that's why you have career officers in the Department of State, one of whom, Mark Tokola, will be sharing with us shortly. He was a senior foreign affairs officer and with different posts around the world for 38 years. And so he has that long-term perspective. Doesn't necessarily mean that it's a Republican or Democratic perspective. Most of the times it's nonpartisan. So you take the people in the State Department who are career, and you try to work that in with members of Congress, and the House elected every 2 years and the Senate every 6 years. And then how do you conduct foreign affairs on that basis? Well, very difficultly, if it's the legislative branch that has the ultimate say on it. And so over the years, you've had all kinds of conflict going on. Not a war situation, but nobody could really find the authority for Thomas Jefferson to make the Louisiana Purchase. Someone said, where'd that come from? And by the time that question was raised, of course, never was a lawsuit. He said, well, you just did it. Where's the authority for states to withdraw? I mean, so in our entire history, we've always been looking for where's the locus of sovereignty with regard to a particular issue. And with regard to foreign affairs, it has to be the president because of the massive amount of information that the president has, along with the State Department and the intelligence agencies, in trying to come to a resolution as to what to do. With the United States becoming involved in Vietnam, back in, I believe, 1973, Congress said, well, let's pass the War Powers Act that says within 48 hours of some type of intervention, the president has to advise Congress, and in certain circumstances, under what's called Section 4.1 or 4.1a, troops have to be out within 60 days. Presidents have adroitly used this to say, well, we'll give you the notice in 48 hours, but Section 4 doesn't apply. So therefore, the 60-day rule doesn't kick in. And we've been on all sides of that War Powers Act. I joined with, in fact, I was going through my voting record here, with Henry Hyde to get rid of the War Powers Act back in a vote that took place in 1995. 201 members voted yes to abolish it. 217 said no to do that. I've always had problems with the War Powers Act, mostly because of the fact that it doesn't work. And then, ironically, I joined in a lawsuit in 1999 with Congressman Tom Campbell of California to invoked the War Powers Act against President Clinton in the Yugoslav situation. The Supreme Court said that members of Congress have no standing, which means that you have no right to bring the lawsuit, meaning that not every constitutional provision, if you can find it, has a remedy. In fact, in a remarkable conversation that I had with one of the Supreme Court justices, with a very small group of people in a coffee, the question was asked who had standing to question President Obama's citizenship. And the justice, whom I will not mention by name, said that, well, I can't say who it would be, but we probably think the only person that could do that would be John McCain. So now you have a constitution that if there's a provision that's faulted, doesn't necessarily mean that you have a remedy. So now comes Congress trying to figure out, what do you do in the midst of all of this? And you have to take a look at some of these votes. I went back to April 28th of 1999, the situation with Kosovo. Very delicate situation. But the Congress, on that day, the House took up three joint resolutions in one bill. A joint resolution just expresses the sentiment of Congress. It just says, we know we have no authority to tell you this, but by the way, this is what you should do. It has no force of law. It tries to make public opinion. And on that day, the only actual bill that could become law, talked about prohibiting money for U.S. ground forces in Kosovo. So that's what we always called a limitation amendment on the ability to limit the powers of the president by the power of the purse. That could work, but in that case, if you recall, President Clinton used air power, where he said no boots on the ground, and air power worked. Even though there was a vote on using air power, and I voted no. In fact, that resolution tied at 213 to 213. So you can see where Congress struggles to deal with particular situations, and it's something that's always going to be there. But what you see there is Congress in a role of the oversight, bringing to the attention of the American people something that Congress perceives the president may be doing incorrectly. We're never going to have a ruling on the War Powers Act because the Supreme Court does not want to get involved in a dispute involving Congress and the president in that situation. War Powers is called a resolution, but it was actually a bill that was passed with the override of 2/3 by each house when President Nixon had vetoed it. So that's about where Congress fits in. You have the overlapping issues of trying to figure out what to do. In the end, you have to trust somebody, regardless of who's in the White House. In the end, members of Congress will take a real broad look at why did the White House act in a particular manner, and then look for ways to justify what the president did. Because you start out on the basis that what he is doing is correct. And that's on a bipartisan basis, because you just got to be very careful to speak with one voice beyond the shores of America. It has a lot to do with it. And the other really difficult thing to do is, once the troops are there on the ground, the limitations amendment to not pay them. Well, who's going to vote against paying the soldiers who are already fighting the war? So even if you're opposed to what they're doing, opposed to their mission, you're certainly not going to vote to restrict money going to them. I think that's about the capsule that I can give on the War Powers Act. from somebody who's been on the inside on both sides of the issue, but it's very, very difficult in these conflicts. But let me also throw this in. People talk about special interests. There are a lot of organizations out there. I think about the Council on Foreign Relations, and we're having the president of that organization speak to us. People from different institutes, scholars, people who have been in and out of the State Department, that will be appearing in this series, and they all are in it with the real long-range goal. And that's something which Congress just cannot exercise because members aren't there long enough. And the last point I want to make is it's pretty easy to take a look at what you did when you were there. But a member's day is usually 18 hours. I would work anywhere from 60 to 100 hours a week. That's an extraordinary amount of time. How much time can you pay to a particular issue, even when it involves life and death? But that's the nature of the American system. And in spite of it, we struggle and do the best that can be done. Ron?
Professor Mazzone, I know we're out of time, but just a quick question. We have some students that are very interested in pursuing careers in law and are interested in constitutional law in particular. What career opportunities are there in that area? Can you speak to that?
Oh, sure. So the first thing you have to do is apply to and then enroll in the University of Illinois College of Law. And we're doing some excellent training. We have, and I'll tell you that we have some of the highest employment rates of any law school in the country,
Including my son.
Oh yeah, yeah. So do that and reach out to me if you want to hear more about that. You know, I always say that whatever area of law you go in, the Constitution is always sort of there in the background, and that it can kind of pop up in surprising ways. I mean, some areas in some areas of practice you are working routinely with constitutional law issues. I mean, if you work in the area of criminal defense or criminal prosecution, for example, that's all that's all constitutional law. Big chunk of the Bill of Rights is all about the rights of criminal defendants. But if you're representing, say, corporations, and you're unhappy with the way in which government is regulating you, then chances are you're going to be involved in thinking about constitutional challenges to governmental power. Don and I did a little program a few months ago on corporations and other entities that are challenging some of the COVID-related restrictions, and so there's that. If you are in the area of environmental law, there are lots of questions about what it is that the federal government can regulate versus what it is that the states can regulate. Lots of interesting federalism questions there that are constitutional law issues. If you go work in any area of the media, there are all sorts of questions about First Amendment rights, and these are just growing in the digital age, and with increasing interest on the part of government to regulate those sorts of entities. If you go work for virtually any governmental agency, you're going to run into questions of the scope of power that you as a government agent is able to exercise. So I think there's some areas where sort of most of what you do is going to have a constitutional law dimension, but there are other areas where even if you try to avoid it, it's going to pop up. And I hope you don't try to avoid it. I think it's some of the most interesting stuff that is out there. And as I said, come join us, and I'll be happy to train you well for those sorts of careers.
Thank you so much for a terrific talk, and thank you for the invitation for students to reach out to you. And it's been a true pleasure.
Good, and I hope to see you in person at some point. I mean, when we're on the other side of this. So,
Good. I hope so too.
all right. Thank you all. I really appreciate
Thank you.
it.
Take
Okay,
care.
my pleasure. Take care. Bye-bye.